raised the kids, you ran the household, and you gave up your entire career so your spouse could grow theirs. And now you're getting a divorce and you're wondering, does any of this count when it comes to dividing property in Wisconsin? Well, I'm Jeff Hughes, lead attorney at Sterling Lawyers, and we have helped thousands of people go through a divorce in Wisconsin. And one of the biggest questions we hear is this: how will the judge value what I have contributed to the marriage? Well, today we're going to break down exactly how Wisconsin judges look at your contributions, financial, non-financial, and everything in between when it comes to dividing marital property. So let's get into it. Number one, Wisconsin starts with a presumption of 50-50 division of marital assets and debt. So this means that everything that you and your spouse earned or acquired during the marriage, houses, cars, retirement accounts, and even debt, is presumed by the judge to be divided equally upon the divorce. But here is a big key. Judges can deviate from 50-50 if it would be unfair, and your contributions played a huge role in that. So number two, that brings us to the 13 factors that judges look for when it comes to evaluating one party's contributions to the marriage. And two of these 13 are the biggest. These are the ones that I'm going to focus on here. And the first one is your contribution to the marriage. And the second is your contribution to your spouse's earning power. And these aren't just about money. These are about homemaking, childcare, emotional support, career sacrifices. They all count. And there's much, much more that I'm not adding to this list. I recall once a lady that we had the privilege of helping, and she had been a stay-at-home mom for nearly 15 years. Her husband built a successful business while she stayed home and dutifully raised their 3 children and ran the entire household, freeing him up to build the business. And unfortunately, when they divorced, that knucklehead argued that she did not contribute anything to his earning power or to the business. But we documented her daily contributions, the equivalent costs of childcare, home management, and sacrifices she made by not building her own career to allow him to build his and their business. And in that particular case, due to all the circumstances, the judge actually awarded her more than 50% of the marital estate because the judge recognized that the economic value of her work was significant. So your contribution isn't invisible, but you have to document it. That brings us to the third factor here. Homemaking and childcare have real economic value, and Wisconsin law is clear on that fact. So the judges must assign economic value to homemaking and parenting. And this means that the time you spent raising the children, that time counts. The meals, the cleaning, the scheduling, all of it matters. Your role at home is just as valuable as the paycheck that the other party brings home from their job. But this doesn't happen automatically. You need to present it clearly to the judge so the judge has something to grasp onto when entering that final order. It's important to outline daily responsibilities, even hours per week, and the impact on the family's success. The judges, they will take this seriously, but you have to document it. So number 4, support for your spouse's career also counts. Did you help your spouse go back to school? Did you take on extra responsibilities so they could work longer hours? These contributions count too, and the judges can award a larger share of assets to compensate you. There was another case that we had once where we worked with a gentleman whose wife went back to school during the marriage. He paid the bills from his job, raised their daughter, and worked nights to make it all work. And she became a nurse practitioner and now makes over $120,000 a year. And when they divorced, he felt stuck. He had no degree, no retirement account, and was still working the same hourly job. And of course, we showed the court exactly what he gave up to help her get ahead in her career. And the judge awarded him a larger share of the property and short-term maintenance. Support isn't just financial. It's not forgotten when the case is presented in the right way. So number 5, what else can impact division of property in a divorce in Wisconsin? Well, in addition to your contribution, the judge can also look at the length of the marriage, the earning capacity of both parties, who is caring for the kids both prior to the divorce and after the divorce, health or age issues, whether one spouse brought more premarital assets to the marriage than the other spouse, and whether there is a valid prenup or postnuptial agreement. And of course, we have spent a lot of time talking about the 2 big factors, but remember, there are 13 total, and the judge will look at all 13, but heavily weigh those 2. That brings us to number 6, What about business owners and complex assets? Valuation here really matters. If your spouse owns a business, you need to know this. Judges don't just look at what the business earned. They also consider its value today, including something called professional goodwill. And this can be significant in the value of a business. It is not uncommon for businesses to be valued well into six figures, and you are entitled to your share even if you did not actively run the business day to day. That's why professional appraisals matter, especially when your contributions help support and grow that business by freeing up the other spouse. One client comes to mind where she helped her husband launch a landscaping business. She handled all the books, scheduled the job, answered client calls. All of that was unpaid. And years later, when they divorced, he claimed that the business was his. And that forced us to bring in a professional evaluator. And that showed that her unpaid labor tied directly to the company's growth. And the court, just as we predicted, awarded her half of the business value because without her, it would not have existed at all. So that brings us to number 7. Contributions matter, but only if you show them to the judge. Do not assume, do not guess. The judges don't award property based on emotion. The judges follow the law, and the law says that contributions count, but you have to back them up. And one of the ways that we have seen clients do this very successfully is through journals, calendars of daily activities, testimony from friends, teachers, families, co-workers, photos, receipts, emails, anything that shows the role that you played in the contribution to the business or to the career of the other party. So remember, when it comes to property division, it's not just math. It's also about fairness and contributions. And in Wisconsin, fairness means your contributions must be valued so long as you present them in the right way. But property isn't the only thing that gets divided in a divorce. In our next video, we will walk through how Wisconsin courts divide debt and what to do if your spouse ran up credit cards, loans, or surprise expenses before the divorce happened. I'll see you over at that video.